There were numerous problems with the court case that condemned Lucy Letby to a life in prison. One of the major issues was that the jury did not have opportunity to hear about all manner of really important information that could clearly have changed the outcome. In this video, I'm going to recount 40 important elements that either did not appear or were not involved in the original court case. Number 1. Lucy Letby was not afforded character witnesses in court, not least because those who were willing to speak in her favour were actively discouraged. Number 2. Consequently, the court and jury never heard from the supporters of Lucy at the Council of Chester, nor any of the context related to what happened to her on the unit, and none of the context from the Thirlwell inquiry. Number 3. Lucy was not afforded any defence witnesses in court. Number 4. Some critics state that the defence could have called witnesses, but then it should also be noted that the reports written by Professor Michael Hall were never shown to the jury. Number 5. None of the previous reports regarding the Council of Chester, including the 2016 Royal College of Paediatrics and Child Health report, were made available to the jury, nor were they mentioned in court. Number 6. The jury was not afforded any access to Counsellor Catherine de Bager, who could have provided crucial context on the supposed confession note presented in court. Number 7. Similarly, no professional analysis of these notes was sought by either the prosecution or defence, thus the court never heard that all such analysis inevitably concludes that these notes are emphatically not confessional. Number 8. The court heard about a supposed confession note written by Lucy Letby. They did not hear about another blue post-it note in which she had written what are clearly exculpatory statements. Number 9. The jury never heard that diaries and private correspondence previously cited in wrongful conviction cases proved to be extremely misleading. They also didn't hear that the supposed code that police identified in Lucy's diaries is absolute nonsense. Number 10. Pathologists and coroners that examined the infants involved in the court case were never cross-examined, nor were their conclusions discussed in court. Number 11. Transportation issues between the Countess of Chester, Alderhay Hospital in Liverpool, and Arrow Park Hospital on the Wirral were never adequately discussed and contextualised. Number 12. The inadequate staffing situation at the Countess of Chester Hospital was never conveyed to the jury, nor were any of the problems with monitoring and ward rounds mentioned or discussed. Number 13. The jury therefore had no idea that the case notes on which the entire prosecution was based are likely to be inaccurate, given that the monitoring and recording of information is a critical part of this process. Number 14. In accordance with this, it was never acceptably portrayed to the jury that the primary prosecution witness, Dr. Dowie Evans, was working entirely from these notes and had never examined any of the babies, even though he admitted that he couldn't be 100% certain of his conclusions precisely because he was working solely with case notes without having even consulted anyone from the Council of Chester. Number 15. Naturally, the jury weren't told that Cheshire Police had bungled large swathes of data on which the prosecution case relied and had completely reversed this. Number 16. The jury also weren't informed that there was a staircase leading out of the neonatal unit, which renders all of the swipe card data included in the court case completely worthless. Number 17. There was no microbiologist in court to discuss the presence of the Pseudomonas aeruginosa and Stenotrophomonas multifilia bacteria and their dangers to vulnerable infants. Number 18. There was similarly little to no discussion in court of the overwhelming evidence for sepsis on the neonatal unit. In fact, bizarrely, the jury was told by Dr. Dowie Evans that none of the infants showed any signs of infection at the time of collapse, which contradicts documented and publicly available medical records. Number 19. Dr. Shuley did not make an appearance in court, which was a missed opportunity, as he could have informed the jury that his co-authored paper, on which the diagnosis of air embolism was almost entirely based, had been completely misused. Number 20. We also know, undeniably, that Dr. Dowie Evans has radically changed diagnoses that were used in court. He also altered some diagnoses during the court case itself. The jury, of course, couldn't have been expected to anticipate that Dr. Evans would change some of his diagnoses and the fundamental foundation of what they were told in court after the trial was over. Number 21. The jury never heard that the statistical work of Professor Jane Hutton was never commissioned on the explicit instruction of the Crown Prosecution Service. Number 22. The jury furthermore never heard from any other statisticians to explain how fatally flawed the methodology utilised to identify a suspect had been. This approach, suggested in fact by Dr. Evans himself according to his own account, was so poorly founded that it made the identification of a suspect virtually inevitable. If Lucy Letby hadn't been on duty with some regularity, it is almost mathematically certain that there would have been a different suspect from the Countess of Chester who would instead have faced a hypothetical prosecution case while Lucy watched on with bemusement. Number 23. The jury was never told about other deaths on the unit, nor was crucial context provided regarding deaths in previous years. It was asserted that deaths on the unit had ceased after Lucy was reduced to a clerical role and that her removal was critical. But the fact that the neonatal unit was downgraded after Lucy was removed was never adequately communicated in court, nor was the significance of this properly conveyed. This was not only a critically important explanation, it had even been anticipated by legal representative Corinne Slingo. In fact, on the 23rd of March 2023, Dr. Stephen Breary stated that there were no more events after Lucy left the neonatal unit. According to Dr. Breary, it was the same staff doing the same job and there were no sudden collapses. Number 24. Similarly, the court was never told that Lucy hadn't been removed due to suspicions about her conduct, but as a form of protection proffered by a supportive nursing team. Number 25. There was no mention of a known third insulin case in court, perhaps not surprisingly, as it calls into question the entire prosecution case. Number 26. The court were never told that the insulin testing used was highly flawed, and that it is certainly not an inevitability that babies were deliberately poisoned on the unit, as had been asserted. Number 27. The jury never heard that several other likely miscarriages of justice are also associated with exactly the same mistakes involved with insulin testing in the case of Lucy Letby. Number 28. Jurors were never informed by experts of the unlikely nature and incredibly rare occurrence of accidental air embolism, let alone the purposeful injection of air. Number 29. The jury were never told that overfeeding babies with milk is a phenomenally unlikely method of murder. It is quite probable that it is even literally impossible. Number 30. The jury never heard of the full circumstances regarding the subpar care of child E or the evidence of considerable bleeding that predated any alleged involvement of Lucy Letby. Number 31. The jury were not informed that the liver damage for child O was likely caused by the medical blunders of doctors working at the Countess of Chester, including Dr. Stephen Breary. Number 32. An almost incalculable number of basic medical facts, procedures and perspectives, which are not contested, were never communicated to the jury. Number 33. The true condition of the infants in the case was certainly never communicated to the jury. In this aspect of the trial, those assessing the case were given an utterly false impression of stable infants who suddenly collapsed or died for no reason. Experts who have examined and commented on the case since have treated this with derision, and their medical evidence and expertise in court would have been critical. Number 34. The jury were not aware that Dr. Ravi Jairam had given a completely different account from that presented in court for child K in an email from the time of the incident. Number 35. The jury never heard about how common accidental tube extubations are and how this is extensively documented in academic studies. In fact, they heard the complete opposite. Number 36. The jury never heard that none of Lucy's nursing colleagues had any suspicions about her, nor that they held her in high esteem. And the jury certainly didn't hear from any of the nurses who still consider Lucy to be innocent to this day. Number 37. The jury didn't hear the statement from Dr. Christopher Green, who chaired the grievance procedure of Lucy Letby, that the consultants on the neonatal unit had likely lied. Number 38. In fact, Lucy's grievance procedure wasn't referenced in her original trial whatsoever. Number 39. Similarly, it is equally unsurprising that the context of Dr. Stephen Breary mounting a 2-year campaign against Lucy Letby before then being called in some 3 years after he began to participate in the Cheshire Police investigation was conveyed to neither the court nor the jury. Number 40. The court were never told that the primary instigator of this unerring web of suspicion being wrapped around Lucy Letby, i.e. Dr. Stephen Breary, was also the golden thread in the investigation which resulted in her arrest. Finally, I would like to mention 2 more things. Firstly, this isn't the only 40 things that didn't appear in court, it is just the first 40 things that came to mind when I compiled this list. Secondly, as important as the elements that were excluded was the fatally flawed and often nonsense information that was put in front of the jury and never properly dissected by suitable experts. If this process had occurred at the time, as is indeed occurring now, it is a virtual inevitability that Lucy Letby would have been found not guilty. Of course, in a healthy criminal justice system featuring competent police constabularies that are capable of investigating dispassionately and objectively, the case would never have gone to court in the first place.